So that's my quick overview of trademarks. I want to discuss a little bit more about inventions. And as I mentioned before, trade secret rights are always the start of protecting an innovation or an invention, and you need those contracts to protect it. So the question is a patent more like a sword or a shield? Does anyone want to guess what they think? All right, a lot of people say it's a shield, but in terms of the legal rights, it's actually the right to sue others or exclude others from making or selling your invention. A patent doesn't actually protect you from others suing you. If they have patent rights, it's possible to invent, as I mentioned, if you had an earth mover invention, and so you decide to start making earth movers, but somebody else has a patent on another part of the earth mover. You might infringe their patent, even though you have a patent, doesn't mean you won't infringe somebody else's. And so a patent is a sword, and it is your right to stop others from using that invention. Ways to protect yourself from others' inventions or others' patents and intellectual property rights are, as I mentioned, having your employees sign something saying they are not bringing trade secrets from other companies, and they don't have a non-compete or an agreement with another company. And also, you can do research to determine if your new product is infringing any patents. And you can try to find those patents, and you can get a freedom to operate opinion from an attorney that can be a shield. It doesn't necessarily prevent you from getting sued, but it can help you if you are sued, and it can reduce the risks and costs. So I'm going to quickly go over what is patentable. So a process, a way of doing things can be patented. A machine, a new machine for sewing, or a machine that does something. A manufactured article, so a new article of manufacture, and that could be like a composition of matter, but actually an article is going to be something you make out of matter. So that's why a shirt. A composition of matter, a new chemical, a new material that has a new molecular structure. And so those are the major categories of patent. And a patent has to be new, not obvious, and useful. Useful is such a low standard, we almost never get a rejection, or I don't think I've ever seen a rejection that something's not useful in my filings. So it only has to have a very basic, minimal, useful purpose to be qualified. The new means it has to be not published or new to what's known. And that's not just the United States, it's the whole world. And then not obvious means you really need something inventive over what's been done before. So with patents, you need to be aware that it's a first to file system. It used to be, if you were keeping an inventor notebook and you could prove that you invented something on a certain date, and then you were working on it for 2 years and then filed a patent, but in those 2 years somebody else filed for a patent, it used to be that you could show that you were first to invent and you would get the patent. But that changed in 2013 when the US went to a first to file system. And so filing is crossing the finish line, but it's only the beginning of a long process. So things that are not patentable are abstract ideas, old inventions, and that can be something that you've even sold for a year or more, or it's already been published or sold by others. There are two major types of patents I work with. There is a third, plant patent, if you've got a new species of plant. But the two that I work with are utility, which is how it works. And it's going to have a claim of how something works or is made. And then the second one is the design. Here it's a design for a phone, and the dotted lines are actually not included in the design. So it's really just the shape of the surface of this phone with the rounded edges and where the screen is and such. So the function is not covered in the design patent.